and live speaker whose specialty is e-discovery and litigation preparedness consulting. Marta Sarensbach is the product manager at Sherpa Software for the development of the electronic discovery products. Her expertise is in compliance and content searching. Before we get started today, we're going to talk a little bit about housekeeping. This webinar is being recorded. You will be sent a link after the webinar to view the webinar on YouTube. Additionally, there will be a Q&A session at the end of the webinar. The questions can be submitted using the panel on the right side of the screen, and we will once again review those at the end of the webinar. Today we will be talking about litigation preparedness and the key to that being information management. Our agenda will include discussing information management, going over the litigation landscape, e-discovery, Federal Rules of Civil Procedure. We'll talk about litigation readiness plans and discuss what you can do in your next steps for litigation preparedness. As mentioned, we'll have a Q&A session at the end. With that said, I'm going to hand this over to Brett Burney, who is going to start us off with defining information management.
Thank you, Martha, and thank you, everyone, for attending today and taking some time out of your day. I know everyone is always busy, so we're thrilled that you were able to join us. So to start off, we felt that it was important to at least define what we mean when we say the phrase information management. Incidentally, some people will interchange information management with information governance. You'll see us sort of use the terms interchangeably because we sort of look at them in that way. There are some folks that will press on to say that information management is more of the umbrella approach to managing information, whereas the governance aspect is more around the policies and retention. But many people will use them interchangeably. We feel that it's important, though, at least, to make sure that you understand how we are using this phrase today. And it basically comes down to information management is a framework of processes and procedures that a company can employ regarding the creation, storage, and deletion of its electronically stored information. And all three of those tasks are important, correct? The fact that we all create information, that's a very important task, and everybody is doing that constantly throughout the day, whether it's emails that you're composing or Word documents that you're creating. Then, of course, it falls upon usually the shoulders of IT to store that information efficiently. And then, of course, something that most people ignore is the deletion of that data. Once the information loses its value to the business has every right to dispose of that information or delete that information. Unfortunately, I think most of us sort of just ignore that because we have this perception that storage is so cheap. So we might as well keep everything if there really isn't a need always to get rid of information that we create. But that is a very important and crucial step in managing the information, as you'll see us talk about today. The primary objective of any information management system is to support the company, the overarching goals of the company or an organization. And we felt that it was important to state that, even though it's sort of obvious. But we find many times that people get so wrapped up maybe in managing the information that management becomes the goal, whereas it's really supposed to be supporting the goals of the organization, whether you're a for-profit or a non-profit. But certainly for many companies today, the goal of the organization is to make money, right? It's to turn a profit, which brings us to this information governance reference model, kind of a nice little colorful Christmas ornament looking thing, right? It's a little overwhelming when you first look at it, we understand. But let me just point out a couple of the wedges here, starting with the top one, the green business. That is certainly a stakeholder in the overall management of information. It's the business people. The information to them becomes valuable in that it can help them accomplish their goals, their tasks, right? So spreadsheets, for example, may be important to a financial officer at a business because it shows them how they are turning that profit, how they are making that profit. But if you go down to the bottom right, the yellow wedge for IT, well, the main responsibility for IT is efficiency, right? Frankly, the IT folks could care less about the content of the spreadsheet that someone is using, But their responsibility is to make sure that whoever needs that spreadsheet can get access to it, that it's available when they need it. And then lastly, on the left side, that red wedge of legal. Frankly, the main responsibility of the legal personnel involved is the fact that they have to define data or information that needs to be retained for litigation purposes. Again, frankly, most lawyers could care less about the content of a spreadsheet unless or until that spreadsheet becomes important or relevant to a litigation matter, right? Then, of course, they're very interested in the content of that spreadsheet. But those are some of the various stakeholders and concerns that go into an overall governance model. I'm going to turn it over to Martha just for a few minutes to talk a little bit more about some of the other little boxes and the way that this all fits together.
Thank you, Brett. So what we're looking at here is a model. This might not be relevant to your organization. Your organization, for example, as Brett mentioned before, might be a nonprofit or an education a university, that sort of thing. In that case, your business isn't to make a profit. Your business is to raise awareness for your charity, for example, or perhaps it's to, obviously educate students, that sort of thing. So your business is going to be different, but it doesn't change the different stakeholders that you have in here. Your legal is going to be associated with risk. You're going to have security teams also looking at the risk. You're going to have your IT department that wants to make everything run smoothly. So you want to look at this as a model, although it is not going to be a blueprint of what you're going to be doing. And the key here is to look at this as something that you can address, either IT side or legal side, it doesn't matter. You have to make sure that your organization is able to address each of these factors and how you're doing the linking of your duties, be it profit, risk, etc., to the information and managing it effectively.
So today we are going to focus a little bit more on that red wedge over there. Now we'll talk a little bit or sort of lean on the orange wedge as well. But frankly, what we're really trying to discuss today and get across is the importance of managing your information to be better prepared for litigation, or it could even be to answer a compliance obligation of some kind. So obviously that's more of what the RIM is, the records information and management wedge down there is for as well. In other words, they pretty much have a lot of the same goals, but sometimes it can be for sort of different scenarios. But the reason we're focusing on the litigation preparedness is because we are getting ready to approach or face the inevitable. Litigation is inevitable if you're in business today. It's sort of a sad fact, I guess, is one way to look at it. Unless you're a lawyer, right? Then it's a good thing that litigation is inevitable. The problem is that most corporations or organizations don't see it as the highest priority. And that's certainly understandable. I'm certainly not judging anyone for that. But there's many other tasks and items on the plate that take more importance on a day-to-day basis, a payroll or collecting money or just the normal day-to-day business activities. Litigation is one of those things that even if you do agree it is inevitable, it's on down the road, right? It's going to happen at some point, and we'll get to it or we'll address it when we get there. Unfortunately, that means you're going to be paying more, and that means you're going to be expending more time when it does happen, because it's a question of when, not if. So to dig just a little bit deeper into that, let me take a quick moment to address today's litigation landscape. If it is something you're going to be prepared for, it's important to understand why that we're involving IT in this, for example. Just a few years ago, any kind of a litigation that would happen would simply involve paper documents. And I say that on sort of a trivial basis, but it's the truth. When we exchanged information, it was all in a physical, tangible medium such as paper. But of course today, all information is electronic. And even if we have a printed document, we know that that printed document was printed from a computer. It was probably created in Microsoft Word or some other kind of word processing application. So the point being that even though we may have a printed document, we still may want to go to the original file because it contains a lot of important information there. So in a criminal standpoint or a criminal matter, when we talk about evidence, it's sort of a tangible item, right? If a thief uses a hammer to smash a window to get inside a residence or storefront, that hammer becomes an important piece of evidence in the criminal matter against that thief, right? We've all seen the television shows who may dust the hammer for fingerprints, or the fact that the hammer was found at the location. Those are important pieces of evidence, and it's important to have the hammer so that we can see it. But when we switch to the civil litigation arena, which is two individuals or two companies suing each other, the evidence there is not a smoking gun or a bloody knife, it's information. It's answering the question of who had access to what information, or who was made aware of this event, or who knew what when. And the way that we answer that question a lot of times today is through information. But as we've already addressed, the fact is it's not paper anymore, of course. It's historically, discovery in litigation has just been one little phase of a broader prospect of, pre-trial and then going to trial. But most lawyers understand discovery is a pre-trial device. It's a series of events that happens that can be used by one party to obtain facts and information about the case from the other party in order to assist the party's preparation for trial. So to make it fair, because we have a legal construct, at least in this country, to where we want to make it fair for both sides. So as part of that, that means that two parties to a civil litigation suit have to exchange information between themselves. One company will collect information that's relevant, give it or produce it to the other side, and the other party is doing the exact same thing. That was fine 10, 12 years ago when we just had paper. You would just walk over to a file cabinet, pull out a folder, make a copy, and send it on. But today, of course, everything is electronic. So that's why we have this little e or big E in front of the word discovery. So with electronic discovery or e-discovery, we are really just identifying the fact that we're talking about the discovery of electronic information. Some of my colleagues and I recently had a discussion, or it seems to come up at least once a year, that maybe we should think about dropping the E from e-discovery. I mean, we talk about the fact that is there enough awareness today that everyone should already know that any discovery is really e-discovery because it involves electronic information today. And we always come back to the same agreement that we're not ready yet, right? There's still some more education to be done. There's still awareness for folks to understand that when we talk about e-discovery, there are some additional ethical responsibilities and duties involved with electronic information that we just didn't have around when we were talking about physical, tangible pieces of information. So with e-discovery, you've heard me say this several times now. We're talking about electronically stored information, many times shortened to just ESI. And that is a wide variety of things, correct? It's not just the Word document or the email, but it's also spreadsheets, PDF files, digital images today from cameras and computers, videos that can be taken from anywhere, Facebook pages even, Twitter feeds, blog feeds, databases, calendar entries, backup tapes still are becoming a big thorn in the side of many corporations. The idea here is that electronically stored information is really just almost a catch-all for so many of the ways that we store information today. And the reason that that phrase came up is in the Federal Rules of Civil Procedure. So you can sort of surmise from the name here that these are literally just a set of rules, a long set of rules, that govern civil litigation matters when they go through federal courts. Now, most states also have a set of their own rules that govern civil litigation. Many of them will mirror what has gone on at the federal level as well. In 2006, the Federal Rules of Civil Procedure were amended to include this phrase, electronically stored information. And it even sort of went on a higher level. It really acknowledged the fact that electronic information stood on the same footing as paper documents, which I know to many of my IT friends, they just kind of scoff at that because it's like, well, of course, duh, wouldn't you think so? Well, up until that time, we really were working within the construct of the Word document. In other words, that's what the federal rules had prior to this. And so we had to describe an email message as a document or a database as a document in order to fall under the federal rules. So it's great that we made these changes. In addition to that, Rule 34, one of the federal rules, now allows each party to specify the form or forms in which electronically stored information is to be produced. Now, that's very significant because in the past we didn't have to worry about, well, how are you going to give me that, or how am I going to produce this paper to you? We just make a copy of it many times. But the federal rules even went a step further in Rule 26, actually directing the parties to discuss the form or forms in which electronically stored information should be produced. Now, in the advisory committee notes there, they even mentioned, of course, again, stating the obvious really, that if you're going to talk about how you're going to produce the information, it's very important for the parties to understand their own information system. And this last sentence is extremely scary for lawyers because it says it may be important also for legal counsel, for the lawyers to become familiar with those systems. That strikes fear in the heart of many lawyers because they have no clue where to start asking about email servers and how the network system is set up. But it's important that they have at least a simple understanding of it so that they can discuss it with the other side. Now, there's a lot more detail in the federal rules now, but the bottom line is that parties are now required to bring some of this information to the table, as it were, so that when they talk about it, then the one party can say, well, you know what, we'll take those Word documents, you can print those out. There's not too many of them. We'll just take them in paper, or maybe PDF, for example. But for this email that's important, we want you to scrape it off of your Exchange server and give us PSD files for each of the individuals involved. In other words, it can be that specific and that detailed. And sometimes it's not, but in many cases now, the parties that understand this concept can actually dictate to the other party how that information will be produced. Which means, of course, if you're thinking one step ahead, that could have an effect on how the data is actually collected by the company and the party involved. So that brings us quickly to yet another colorful model. This is the e-discovery reference model. This is actually the first model that was promulgated in I believe it was just at the end of 2004, beginning of 2005. And it's the same group that has actually came up with the information governance model. And the main reason is because while this EDRM, e-discovery reference model, sort of gives an overview of the entire litigation process, that first orange box there was always a black hole for so many lawyers. You know, for IT folks, we understand it involves information lifecycle management, records retention policy, enterprise content management, but for most lawyers, it was sort of just something that was handled by someone else. So that's one of the reasons the information governance model was created. By the way, the rest of this model is sort of applicable to the stages, I guess, as you could say, through throughout a litigation matter. The blue boxes there in the middle, the process and review and analysis, are frankly where most of the lawyers would come into play. Whereas a party will collect the information maybe at the onset there. You see that second purple box. It really comes down, the lawyers get involved when we start to review this information. And frankly, this is one of the main reasons that e-discovery is so expensive today. Because what we mean in that review box is that each lawyer is looking at each individual document that is then collected, which is important. In other words, that's one of their responsibilities, so that as they look through this information, they can make a determination of whether the document is relevant to the case, in which case it can be produced, or if it's relevant, is there some kind of a confidential aspect to the document that would prohibit it from being produced to the other side, or is it covered by the attorney-client privilege or something similar to that matter? But in order to make that determination, lawyers routinely have to look at every single document. So you can imagine that if you are paying a lawyer their hourly billable rate to sit there and look at every document, it's important to put some of these processes in place. most notably is the background triangles in this visual diagram. You can see that this yellow triangle, which stands for volume, starts off big at the information management side, correct? And as we go through the entire process, we end up getting a smaller subset of that information. That's the most relevant documents that would then be taken to trial ultimately if we go to the presentation box at the end there. In other words, the more information that you collect initially, if you don't have proper information management procedures in place, then of course that means the lawyers are going to have more information to review. I'm maybe oversimplifying it here a little bit, but if you can put some of these procedures in place to better manage your information so that you have less of it, then that ultimately means when you get down to the lawyers looking at every single document, they will have less to look at, and thereby it will take less time for them to do so. Instantly I should say, I keep talking about e-discovery mainly in the context of a trial or a litigation matter. But Martha, it's good to point out that that's probably only because that's the world that I live in more so than not. But these same principles can be applied to a variety of different scenarios, such as freedom of information requests, right? If that's something that is important that your organization has to look toward, well, a lot of these same principles can be applied to there. Subpoenas, for example, from regulatory commissions, or even subpoenas as the company is a third party to another litigation. You may not even be directly involved in it, but you may be a third party, which means that all of these same principles apply to you as well. And then lastly, compliance obligations or some kind of audits or SEC compliance issues that may come into play. A lot of this can be applied in the same way. So I'm going to turn it over to Martin now to talk a little bit more about specifically how information management plans can help out.
Yeah. And the key here is that if you have an effective information management system, that you're organizing your data effectively, that you know where your data is, everything else just becomes easier. Litigation becomes easier, subpoenas become easier, and honestly, running your day-to-day business becomes easier. If you know what tools you're going to use, what processes you're going to follow, where your data exists, the rest of it all comes down the pike. So what does that mean? So basically, what's happening is if you do get involved in litigation, the meet and confer requirements, you actually have to meet with your opposing counsel at the very beginning of litigation, and you have to discuss, well, where's the data? How much of it is going to be relevant to your case? What is reasonable to produce? And without this effective information management, you or your representatives are going to be at a loss going to those meetings. And quite honestly, somebody could say, I want these all produced in, paper format. Well, when you go back and discover you have, oh wait, there's 100,000 gigs of data here or something along those lines, obviously it's not going to be very effective. So that foreknowledge is better in the beginning. Now, in addition to that, the better you know your systems, the better organization, the less cost, the less stress, because when you have litigation or subpoenas or whatever else that you have to do, you're usually under intense time constraints. And those intense time constraints come along with extreme amounts of cost. So again, if you have your tools in place, everything else, you don't have to have out-of-budget expenditures. And in addition to all of that, you can issue your litigation holds. You can go through the processes quickly. You're going to minimize your risks. You're going to avoid sanctions. And honestly, you can run your business better. Brett? Now, there are some negative consequences for not doing your information management. First of all, as we talked about before, there's going to be large amounts of data to process and review. Without the organization that you require in proper information management, you're not going to be able to search properly. You're not going to be able to do your data maps. You're not going to be able to audit your process. So if you ever have to defend that process, you're probably not going to be able to do it. And once again, you might have negative judgment against you. There's going to be delays in the processing, and you're just going to add expenditure. You're going to have last-minute expenses, and quite honestly, it's quite possible you're going to miss things in this whole process. You might have key smoking gun evidence that gets out. You might have privileged information that's not even supposed to be produced to the other side. That might not be caught because your processes are not in place. So once again, the sloppy processes, bad information management, potential for missteps, and its potential for a lot of negative consequences, not just in litigation, but just in the business processes as a whole.
Excellent. Thank you, Martha. So quickly, I promise I won't spend a lot of time and bore you with stories on the cases here, but I just wanted to give you a few examples from current litigation cases that for some examples of information mismanagement, if you will. First off is one that all of us are probably familiar with. We've at least seen the headlines, even if we've tried to avoid them. But you can't miss the fact that Apple and Samsung have been going after each other's throats on a lot of patent litigation that's been happening. And there's a lot going on in this case, of course, but one of the opinions that came out over the summer was the fact of a judge sort of admonishing both sides in their information management procedures. The first off of that is Apple accused Samsung of allowing relevant emails to be deleted as part of their automatic policy that deleted emails after 2 weeks, which is a good program to have. There's nothing wrong with that per se, except that if Samsung had known about that they should have preserved some of those emails before it happened, then they had a responsibility to preserve those before they allowed them to be deleted. Well, Samsung just didn't sit idly by. They sort of had a counterpunch back to Apple, saying that, well, Apple has a policy in place that limits the amount of email that employees are able to retain. You know, some organizations put a limit on email inboxes at 500 meg or a gig or whatever the case may be, which is great. Again, nothing wrong with that per se. In fact, that's a very good management capability for information. But the accusation was Samsung was saying, well, Apple's employees couldn't do a good job of preserving their email because they didn't have enough storage room. Now, again, there's been a lot that goes on in this case, but the judge came down very hard on both of the parties here, saying that they both should have done a better job on managing that information. Another case is NAECO Materials Handling Group against Lilly Company. The court said that the defendant here, the Lilly Company, was negligent in discharging its discovery obligations because it failed to prevent emails from being deleted, it failed to prevent data from being overwritten, and it failed to identify and preserve backup tapes, which might contain the only area of electronic evidence for the case. Now, we don't know for sure if those were the only containers of evidence, but the court was upset that they let some of those backup tapes be deleted or overwritten, you know, which is a typical scenario here, that the old backup tapes are overwritten. But in this case, that may have been the only location of the relevant information. The court was not happy. So they required then the defendant to go back to the drawing board, spend more money, more time on looking for the relevant information and producing it if they were able to find it. And in addition to that, the court also said, you're going to pay the other side's lawyer fees on top of all that. And that's a fairly typical, I guess, a disciplinary action that a court will throw on or pile on a party that they don't like too much. In other words, they say, well, you're paying your own lawyers, but you know what? Because you muddled this up a little bit, you're going to pay for the lawyers for the other side as well. No one wants to be in that position. And then my last example here was a discrimination case. Ms. Northington filed suit against her employer, former employer, for sexual discrimination, racial discrimination, and being overlooked because she wasn't considered for another upper, higher position. Well, the court came down pretty hard again on the defendant here, saying that the company was grossly negligent, never a phrase you want to hear from a judge. The judge says the defendant here, the company, was grossly negligent in its attempt to secure relevant documents for the litigation matter. They just did not do a good job, and they couldn't prove otherwise. They couldn't show that they attempted to do a good job doing it. And it didn't look good at all. In fact, the company was ordered to go back, spend more money, take more time, find the relevant information if they could. Oh, also pay the other side's lawyer fees. And then the third shoe that dropped here is the judge said, I'm going to instruct the jury that if they want to, they can find that the company was negligent across the board. It's sometimes what we call an adverse inference instruction. It's never a good thing when the judge says, jury, you can find that the company did a very bad thing. Because it's not going to end well, right? We all know that. So some of those examples that you just don't want to be in. Okay, let's change gears now. We've talked about all the scary aspects of what it means if you don't manage your information right, or why you should. But let's talk about what you can do differently now. One of the first things that I work with my clients, and I know Martha works with her customers as well, is really talking about a litigation readiness plan. And part of this, of course, is better managing your information. But it's really having a plan that you can follow when the inevitable litigation happens. The problem is, anytime that I bring this up to my clients or discuss this with folks, it sort of freezes them in place. They just don't know what to do. They don't know where to start. It's an overwhelming concept to try to understand all your information systems. There's just too much out there. It takes time. There's other business priorities that should take precedence over something like this litigation readiness plan. And while we understand that, hopefully you're walking away today with at least an additional inkling of why it's important to start considering some of these things. So we want to give you a few steps of where to start in developing a litigation readiness plan. First off, the first thing you need to do is understand the company's litigation profile, or the organization's litigation profile. And again, I'm going to be talking about it in the context of a litigation, but this could apply to compliance requests and et cetera. But the question you need to understand, or the sense is, what kind of information is important? So, for example, if you are a manufacturing company, you probably have several product liability cases that you have to deal with throughout a year. In other words, you have customers that are complaining about faulty products or defective merchandise, et cetera. So they're going to bring suit against the company to recover some kind of agreement from the company. But what kind of information is important in there? Maybe spreadsheets or sales figures, for example, or maybe some engineering markups or something. If you're a technology company, such as the Apple and Samsung, maybe you're involved in a lot of patent litigation. You're defending your patents, or you're going after folks that you believe are infringing upon your patents or copying your patents. Well, in that case, what are important information there? Maybe design notes from engineers, for example, or in the case of Apple and Samsung, is what emails were being passed back and forth at what time. Or one last example, let's say you're a financial institution, as we said. In that case, you may be more concerned about SEC investigations or something along those lines that you're worried about. So in all of those scenarios, there are going to be important pieces of information. The discrimination suit we were just talking about. In that case, it's probably going to be the email of that lady's supervisors or the managers, right? Because we want to know about how they were talking about her or what they were thinking about her. We may want to get into the HR records in that case. So if you're a company that has to defend a lot of discrimination suits for whatever reason, that could be email may be a first place to start for gathering that kind of information or being prepared for litigation. So again, this all is going to depend on your specific litigation profile. But here's just an example, at least. If we talk about email, because it usually is sort of that low-hanging fruit, as we call it, because there's always going to be some kind of relevant information in email. And so if you don't have a plan or you're trying to find somewhere to start, email is usually a good bet. Email is always important, as I said, because it just contains some of the juiciest conversations. It's what we call the smoking gun sometimes, to sort of borrow from the criminal evidence parlance. But the idea is people, for whatever reason, are just informal in their conversations in email. And so that's a hotbed of good information if you're looking for something really juicy. But in addition to that, it's not just the conversation. Email has almost become a de facto filing cabinet for so many of us today. So, the vast majority of the email that we gather today in most e-discovery cases isn't because of the conversations per se. It's because of all the documents that are attached to all these messages. Email is sort of the way that we transport documents around. And so most of the collection that we have is not necessarily from, network shares where you might store Word documents or other places, but email is where we gather so many important and vital documents there. So what do you do if you recognize email is an important place to start? You can start from the beginning. Let's decide on a retention period, after which time that these messages will be deleted. And so this can come in a variety of situations, but most notably, or at a simple level, you may decide after 30 days or 60 days, all of the email in each inbox will be deleted. Now that can be very scary for companies that have never implemented any kind of a retention period, but it's necessary. And the company has complete authority to do that. There's nothing wrong with creating that because, frankly, we all know the vast majority of our email is worthless, certainly after a few days, right? It's about the donuts on the 5th floor or whose birthday is coming up. And if people have that inbox that every 30 or 60 days that information is deleted out of there, or every email that's older than 60 or 30 days is deleted off, well, that's very good management aspect. Now, you have to also, in addition to that, though, provide individuals with an option for saving that email. And so at many folks that I work with, for example, will have a 30-day retention period on their inbox, but they'll have subfolders in each of the individual mailboxes so that they can move messages to that subfolder, which of course will have a longer retention period or maybe no retention period applied to that. So that's at least one other option there for folks that need to save some of that information. So I was going to ask Martha to come back and talk a little bit about some of the tools and systems, because there are many platforms out there that can help you achieve this management plan or this retention period. And so I'd like Martha to address that just a little bit, please.
Sure. Now, a lot of the systems you actually use day to day, if you use a standard Microsoft Exchange, Lotus Notes, what have you, they do have basic retention functionality inside the tool. However, a lot of times a company's litigation profile or their IT data map is a lot more complex than that. So, for example, if they need to retain based on custodians and keywords and date, for example, that is going to need a more complicated retention policy. Well, they have other tools, and Sherpa does make some of them as well, that will apply those retention policies. The other thing you have to be aware of is, again, where does your data reside? If you're doing, for example, a hosted exchange, or you're doing cloud-based email, are those systems going to allow you to apply retention policies? And if they are, how much extra is that going to cost you? So these are all kinds of things that you have to think of as part of your litigation readiness, because again, it's one thing if you have all that data internal and you have control over it, but a lot more people are moving to systems that they don't have that control, and they need to be able to talk to that when they're setting up their service contracts.
Yeah, that's an excellent point, certainly about the cloud aspect. Thank you, Martha. So after tackling email, what are some of the next areas? Well, it sort of should go without saying, I hope. There's just numerous areas in each company that will have relevant data or have data that could be relevant as far of a litigation matter. And so what I typically recommend is sit down and sort of make a prioritized list of locations of data that are important. We've been using this example of email, for example, because it is a typical first area that we start looking at, but that may not be the most important location of data for your company or organization. But if it is, as an example, depending on your profile, you might want to next then go to network share drives. Most companies have network servers where people can store certain things in folders, or the marketing department, for example, may have a folder on this network share, and other employees have their own share drive. That is very important as well. And maybe that's the next area that you can go to after you spend some time talking about email. The general point I'm trying to make is make a prioritized list of these data locations, and then frankly start from the top. I mean, if nothing else, you're able to show a court or your outside legal counsel that you're making a concerted effort to go through and start managing these data locations better than you were before. So that's literally the first step. If you just don't even know where to start, just get together and start writing down some of these data locations that are important. And then after that, we can move on to some other areas, the next steps in litigation preparedness. One of the first things that I continue to harp on with a lot of my clients is developing, I call it a litigation response team. You can call it anything you want, an e-discovery team, but the fact of the matter is every organization and company needs to have someone that's identified as sort of the go-to person when litigation happens. Now, if you're a big enough organization to have IT folks and business folks and legal representatives that can all come together as part of this team, that's great. If you're at a smaller organization that only has one person that can wear a lot of these hats, that's fine as well. The important thing is that somebody is identified to sort of take charge of this when it happens, because it will happen. The primary responsibility of a litigation response team is to literally oversee the company's tasks and responsibilities in litigation. And there's several of them. We've already been talking about some of them as far as collecting the information. But one of the things that a litigation response team could do is create a data map for the organization. Now, when I say a data map, I'm not specifically referring to an illustrious network diagram. I've seen some of these IT network diagrams that, with super users in Visio that come up with these beautiful diagrams that show every connection possible. That's overkill for what we're talking about here. On the other hand, we don't want underkill, right? We need something that's a little bit more than what you see on the screen here, just saying computers and stuff. Now, I've got a quick example here that's not much more than that, but in the upper left-hand corner is sort of the more important aspect here. It's recognizing that you have an email server or a backup server. And in addition to this basic diagram that I may use to start from the beginning here, I may include things under the email server, for example, such as how many accounts are on there, how many users are involved in this server, because sometimes there's multiple email servers. I may make sure that on this data map we have the retention periods already mapped out, because this literally becomes a document that you may take with you to the meet and confer, which Marcia referred to earlier. When you go and sit down with the opposing counsel, this is a way that you can discuss the information systems that you have in place. Another responsibility that a litigation response team could be in charge of is the legal hold notification. So when a company is sued, or when a company or organization is involved in a lawsuit, they are required to put a hold on the information that is relevant. In other words, we have to preserve the relevant information to give to the other side. Because if you don't, then it's not fair, right? So you get sanctioned for that. You get punished for not properly preserving the information. So I was going to cover 4 quick duties here, which you'll hear sometimes referred to as the Zubilate duties, because it came out of one of the first e-discovery cases back in 2004. It was a series of 5 opinions out of the Southern District of New York, the Zubilate. And it was, the name of the lady is Laura Zubilate. She sued UBS Warburg for discrimination, for sexual discrimination. They eventually settled after years and years of going through, but out of this, the judge was very upset that UBS Warburg did not properly preserve the information. So the things that the judge put into her opinion, that the company must issue a litigation hold at the outset and periodically reissue that hold. Now, that sounds like it should be understood, but for lawyers, that's just not the way we've worked in the past. In the past, when we issued a litigation hold, we just may have sent off a letter to the client and said, hey, hold on to everything that's relevant to this case. And that's it. They would go and pull it out of the file drawer and make a copy of it, and it would be done. But in this case, it's important, she says, to periodically reissue the litigation hold, because we know that information systems will overwrite, or things can get changed or modified by a simple copy and paste at certain times. It's important to communicate directly with the key players. If we go back to the discrimination suit we've talked about, the key players there are probably the supervisors of the person that was let go, or the managers that were involved, or the HR person that was involved in the case. Those are the key players. In many cases, in other litigation matters or investigations, it's the chief executive officer, correct, or other executives in the company that are the key players there. Instruct all employees to produce copies of relevant electronic files. That could be in a myriad of different ways. Electronically, sometimes it is okay to produce it in paper. And then, lastly, make sure that all media which the party is required to retain is identified and stored in a safe place. And that is really just communicating that vital responsibility of preserving the information so that it cannot be accidentally deleted or modified or anything else. It's extremely important to preserve that information. So I was going to ask Martha to come back in and talk a little bit about some of the next steps in litigation preparedness.
Right. Once you have that litigation response team, one of their first tasks among these others that we've been discussing is, if you don't have a retention policy or destruction policy, depending on which way you look at it, you have to implement one or revise one. Because as we've been kind of emphasized here, if you have data that is in your system, that data, you're liable for that data. It doesn't matter what kind of organization you are, that data is a liability to the company. So you really want to restrict the data that you're storing to data that is relevant to your business needs, number one. Number two, even that data that's relevant for your business needs, you want to make sure that it is organized properly. And all this can be helped with using a retention or, again, a destruction policy. These policies are based on a number of items, including usage, regulations the company might be under, the different standards that the company has itself. So how do you go ahead and create one of these? Well, you start by identifying the business purposes and the locations of your data stores. For example, if you're a financial institution, your brokers, for example, are under different regulations than, for example, your HR people who are under different regulations than the receptionist. Each one of those people might need a separate retention policy. So you, as part of the litigation response team, must craft a policy potentially for each of those different areas. You need to catalog what software and data store, what software is creating what types of data. So, for example, email we've talked about. If you have Microsoft Exchange stores, you might be creating, lots and lots of email messages. So let's say you're using Salesforce or PeopleSoft. Well, is it possible that you might need some retention on those as well? You might have some limitations imposed by your IT department. In other words, the effective running of the company might be imperiled by putting some of these retention policies on there. Alternately, it might be very difficult and challenging to issue retention policies on things like cloud-based data stores. If that's the case, you have to address them, and you need to have that listed in your retention policies. Backup tapes are another area of challenge for IT. You need to have it, and most of the time IT does have some sort of system of backup tapes, but you need to make sure that all of these things, once they're implemented, are audited. Make sure there's not backup tapes hanging out at like someone's house, which is the case that one person has, because again, that data is going to be liable. And last but not least, again, if you have external regulations applying, be it SEC, FCC, HIPAA, etc., you need to make sure your retention policy falls under those regulations that are required. And last but not least, one of the emerging areas, if you will, of law at the moment is under social media. We're talking Facebook, LinkedIn, Twitter. All these kinds of things are being heavily used by companies to promote their services. That's all. If the company is the one who is actively updating these pages, you are liable for that information. So you might actually need a social media policy, not just on the company-issued items, but what about users inside your company using maybe their personal accounts? Right now, it's a very murky area of law, but is something that you really should address as part of your social media policy. And last, and I think I mentioned this before, I will mention this again, every single policy that we talked about here, be it litigation hold, be it social media, be it retention, if you don't continuously audit these policies, if you don't continuously verify that they're actually working, when you issue a litigation hold, is it going to the people who need it? Are they doing what they're supposed to? Is your retention policy actually removing data it's supposed to remove, or are people trying to circumvent it? These have to be audited, because if you come back again in 2 years' time and you've never checked to see what the data is, can you go back and defend that process if you're finding data outside of your retention period? So those are all things you need to be aware of when you're looking at retention policies specifically, but all policy in general. Okay. Brett, did you want to close?
Yeah, we just had this one last slide here about with some resources for those that wanted to dig a little bit more. EDRM.net is the go-to website for the eDiscovery reference model. but it is also the site that you'll find the information governance reference model with a lot of helpful information on there. I always like how EDRM.net has the boxes. Each box of the eDiscovery reference model is clickable, so you can read about each box that you're more interested in. The Sedona Conference it's more of a think tank that's been around for a long time. They have a lot of great publications at this URL that are things like the eDiscovery glossary, for example, or how to implement a legal hold. Some excellent sort of academic papers, if you will, that routinely get referenced and cited by judges in eDiscovery opinions. And then, of course, we have Sherpa Software's website, which is also great. Some other great white papers and lots of great information for those looking to better manage both their Exchange server side as well as their Lotus side. And then my website is at the bottom, burningconsultants.com as well.
Okay. Well, with that note, we'll go to some questions. There is a Q&A as part of the console. And if you want to go ahead and enter some questions in there, please feel free to do so. I did have a question on, we use an abbreviation RIM, that's Records Information Management, for those of you who are not familiar with the nomenclature. Basically, the records managers, especially in larger companies, have a huge role in litigation preparedness, number one, and certainly in information management. Document retention, those types of things, they're the ones who coordinate it. And as part of the suggested resources, there's actually some really good resources on the Association of Records Managers site, and also, Brett, what was the other one? It is the...
Yeah, well, it's two A's. It's ARMA, A-R-M-A, .org, which is what you just said, right, Martha? And then the other one is AIM. It's AIM with two I's, so it's A-I-I-M. I forget what the acronym stands for. I used to know, but it's AIM.org with two I's and then ARMA.org. Both of those, just like you said, Martha, are more focused on the records management, and that's basically they're organizations for records managers. But what I have loved to see over the last few years is both of those organizations have recognized and sort of embraced that one of the additional arms of their organizations or what they do is the fact that it's litigation, it's electronic discovery. So you'll find some excellent resources that sort of cross the border between traditional records management and litigation and e-discovery as well on both of those websites.
Okay. We have a question here, and what solutions do you offer related to information management and litigation preparedness? Brett, if you want to talk a little bit about the solutions that you offer, we can talk a little bit about Sherpa.
Oh, sure, absolutely. I thank you for the question. My role many times is more on the consultant side. So if I go into a corporation, it's more to do an assessment of what you have, sort of a knowledge gap. I do a lot of reviews of different products, and I've worked with a myriad of different products, including Sherpa's products, so that if I go into to a location and they're looking for ways to better manage, what are some of the directions that I help corporations work with both the vendors and their legal counsel and set up RFPs and whatever else that they need. So I don't sell a product, but I know the folks that do sell products, such as Sherpa.
Mm-hmm. And Brett is being very modest. What Brett does if you basically don't know where to start, you call someone like Brett, and Brett's going to come in and help you put together your information or your litigation preparedness, and he's going to help you look at your areas of risk and can go ahead and tell you which the different places are. So it's very, very helpful, especially if you don't have that expertise in-house yourself. Now, Sherpa does content management tools. We do information management tools for email, for electronic discovery, and other areas. I do highly recommend you check out our website, because in addition to our product offerings, we do have a number of resources, including white papers, other webinars, things like that can help you if you need to just start getting, if you're just beginning in this type of preparedness. Do we have any other questions? Okay, we don't seem to have any other questions right now. So why don't we go ahead and turn it, I'll turn this over. Brett, thank you so much for joining us today for today's webinar. Once again, this is going to be available via YouTube. You will get a link emailed to you, not just on this. We're also going to be having a white paper to follow up with on this webinar, which will give a lot more detail than we were able to cover today. And thank you once again for joining us, and we hope to see you at a future webinar. Brett, thank you very much.
Thank you, Martha. Thank you.